So, a certain social group had gone to the court. Sir, we would like to marry. We are not man-woman, we could be man-man, woman-woman, whatever, non-heterosexual, same sex. And please allow us, Constitution does not allow us, law doesn't allow us, so we are being deprived of certain rights. We can't adopt, inheritance, tax. We can't open a joint account. So many hurdles are there. Life is not peaceful. And on top of that, we are also getting harassed by the police. So, sir, allow us to marry. And, or form a civil union. Not, just short of marriage, there is a civil union. We'll live together. We'll have a lot of rights like a married couple. We may not have all the rights, but some legal protection is there. It's not merely living in relation, it's living together relation. They went to the Supreme Court. Supreme Court formed a 5-judge constitution bench. Constitutional issues, right to marry. That's a constitutional issue. So they made a 5-judge bench. Whenever you have a constitutional issue, reinterpret the constitution, you have a constitution bench. Minimum strength is 5. Minimum. You could go. Keshavananda had 13. That's about the largest. So now, certain questions come up here. You have to interpret the constitution. Article 21. Right to life and personal liberty. Life means, you have to marry for life to carry on. Personal liberty, I have the right to marry. Personal liberty, Article 21. That's what the Supreme Court said in Hadia case also. The lady from Kerala who married a Muslim guy, and she loved him, he loved her, but there was an outside problem and she had to go through hell. Finally, Supreme Court said, okay, you are a major, you go ahead, marry whoever you like. What's our problem? You marry whoever you like. Don't marry. It's up to you under Article 21. So many articles, so many rulings of the Supreme Court in which they had said right to marry is a fundamental right. Under Article 21 primarily, Article 19 also you got the freedom to marry, choose your partner, get married, live. But in the verdict of last week, maybe earlier this week, today is something Wednesday, Thursday, whatever, maybe I don't know what is today, somewhere there. So, 2 days back, I think, or 3 days back, the Supreme Court gave the verdict. It's called the Supriya Chakravarti. The lady who went there. There is a law made in 1954, Special Marriage Act. You belong to 2 different religions. You don't want to go under any one of them. You want to have a non-religious marriage, go to the officer, get registered. There are some formalities, fulfill them. They could be problematic, but that's how the law is. Go ahead and get married under 54. It doesn't fall within the scope of any particular religion. No personal laws, that is traditional laws, customary laws. In that, a couple means man and woman and heterosexual. You just got to change it to spouse rather than husband and wife. Spouse. And these people who went to the court requested the court, sir, you change that term there, make it spouse, so that we also can be covered by it and we can also go to the government officer to get married. And the court went into all that, 5 of them. Basically, they didn't want to go against the society, against the condition of India today, tradition, custom, all that. They didn't want to. So they said no. What did they say no to? 3 things they said no to. No. Before that, there is no fundamental right to marry. You have no fundamental right to marry. Marriage is covered by laws of the parliament. Marriage is in the concurrent list. Either the parliament makes law or the states make law and whatever. And so, nowhere in the constitution, either as a fundamental right or a non-fundamental right, outside part 3, you have the right to marry. You can only have it in the 19 or 21, neither of them talks about marriage. So, formally speaking, literally speaking, if you look into the constitution 1,000 times, you will still not find the right to marry there in the constitution. So, here they said there is no right to marry, which is a fundamental right. You have only a statutory right made by the parliament, made by the state legislature. So, that is the headline. There is no right to, fundamental right or constitutional right to marry. It's a statutory right that is made by the parliament. So, that's okay. Nobody has it. But I can show you 3-4 verdicts of the Supreme Court where they clearly stated that. Actually, it came in the preliminary examination. If you go into the question paper about, say, 2019, around there, 2018, somewhere there, Hadia case, around there, you had the question in the UPSC, right to marry flows from which article, and they gave you choices, 19 is that, 21 is the answer. But then here in this verdict, they have denied that the right to marry is a fundamental right. They confirmed it as a statutory right. That's okay. What did they say? They said, no, you don't have the right to marry. Law says you don't have the right to marry. Our job is to interpret the law, not to make the law. We are here to review, not legislate. So, law has to be made only by the parliament. In this case, concurrent list here or there. You could have law done only by the legislature, and we do not make legislation. So, leave us out of it. We cannot accept your petition to amend the Special Marriage Act, point number 1. And then the next best is, can we make a civil union legally? No, you can't. You can live together. You do what you like. We'll ensure, we'll tell the government to set up a committee not to harass you and stuff. But civil union as a legal entity also we can't grant you because it will have certain implications on, adoption, inheritance, taxation, immigration and all that. We are not here to upset the apple cart of Indian society today. I watched the judges deliver their speeches, and one of them said, it cascades. We give you this, another right, another right, another right, another right, and it cascades. And we can't make changes in so many laws. We are, after all, the court. We are not the legislature. So please, leave us out on the civil union part also. Then they said, can we at least adopt? Okay, 2 of us are living. Surely we would like to have children. Who doesn't love children? Can we adopt? Lot of kids are abandoned. Can we adopt? Then they said, again the cascading effect will come. Adoption, inheritance, succession, all that. So, you don't have the right to adopt also. So, 1, 2, 3, all the basic requests shot down. So what did they give you? They gave you some sort of SOP. We are telling the government, set up a committee under the cabinet secretary. No timeline. Nothing about composition, nothing about the mandate. A few things thrown in about the mandate. So they will ensure that you're okay, you're not harassed and stuff. Any other rights they can confer on you, they'll decide. So that committee, we don't know whether there's nothing, we don't know when the committee will be set up, who will head the committee, who will compose the committee, what will the committee do, how long it will take. We have no idea, nothing. Point number one. That's a huge help they have done, number one, help. Second is, we leave it to the parliament to make the law. So it's the ball is in the parliament's court now. Point number two. Point number three is, transgenders are there. Obviously, they can get married. They have a right, statutory right to marry transgenders, because that's heterosexual. I claim to be a man, you claim to be a woman, we are together. Vice versa, we are together. So nobody can stop us from getting married. We are heterosexuals. So conventional couple we are, and so we'll get married. We have the right to marry, statutory right like everyone else. Transgenders are okay. Parliament should make the law, not us. And the committee will protect you. These are the positives, if you like. Those were the rejections, if you like. This is the takeaway from the Supriya Chakravarti case 2023. The rest everyone knows, there are arguments for and against. UPSC asks you, what do you say to the UPSC? Sir, law evolves, society evolves along with the law, and the Honorable Court felt that rapid social change is not advisable. Society should evolve gradually, step by step. They had decriminalized, and the next step could come about whenever. Already there is a committee being set up, sir. That is how social evolution takes place. UPSC is happy. And if they are happy, you will be happy. So this was the case and the, components of the ruling. And nobody is going to ask you critically examine. Critically examine generally, in my view, see, I keep talking to a lot of people who go to the interview, and they are very they have an open mind. They facilitate social change. After all, people are crying out, you are young people. But the judges are, each one is 64, 63, 62. They were born those times. You are, young, and your demands and expectations are different. There's a huge generation gap between the judges and the country. The country is full of young people. So, yes, that's where it rests.